You're listening to Let Me Tell You Why You're Wrong, all on Georgia Radio Network.
Thank you for tuning in to part 2 of the 117th episode of the Let Me Tell You Why You're Wrong podcast. I'm Dave Roberts. With me, as always, is the brains of the operation, writer, journalist, TV personality, Jessica Szilagyi.
It's me again.
Yeah, I can't even say what happened last week, because we're literally recording at the same time. But we're going to go ahead and remind as we open up that these are our opinions and the opinions of our individual guests, not necessarily those of All on Georgia or any All on Georgia reporter not appearing on the show. We're going to get right into it. We're with our second guest. And now we have joining us attorney Chris Howard, criminal defense attorney, owner, operator of Bulldog Bike Law, 3 years as a prosecutor, and 3 years as a defense attorney. And we won't hold this against him. Political experience working in Georgia Congressional Office, Lieutenant Governor Casey Cagle, Speaker of the House David Ralston, but he is a certified gun nut and freedom lover. Chris, thanks for coming on.
Yeah, I appreciate it, Dave.
So, we wanted to have a criminal defense mind to kind of delve into the McMichael Arbery situation down in Brunswick.
Yeah, and obviously I think everyone's been watching that and sort of keeping up with all the updates as the facts trickle in.
So, and correct me if I'm wrong. The way we're going to talk about the facts of the case. Arbery was seen snooping in a construction site. The McMichaels take it upon themselves to hop in a pickup truck and go and enforce the law. And at some point, there's a confrontation, and impressively, Arbery gets hit with a shotgun 3 times. Correct.
So, a few important facts there I think that we should talk about from what we see in the video is he enters into the home. He's not seen stealing anything from the home. He is walking around the home. A neighbor comes out across the street and appears on a video to yell something or say something to him, at which point he does take off and sprint down the street. The McMichaels are not seen anywhere in that video. At some point while he's running down the street, I believe the McMichaels report that they see someone running at a high rate of speed come past their house, at which point they suspect he may have been associated with some break-ins that they believe may have happened. They just kind of say recently, and they begin to approach him armed, father and son, with one with a shotgun and one with a handgun. They then, in the video, pull the truck in front of his path, and Mr. Arbery attempts to run around the truck, is confronted by the individual with the shotgun, then approaches the man with the shotgun, grabs the barrel. I believe one shot we now learned has gone off into his hand, and then 2 consecutive shots then go off into his chest, one directly and one beginning to point up as the barrel of the shotgun is being pushed or pulled away. So, with those facts there, I just wanted to add in some of those facts, is that it's important to look at who saw what and when. And that's because we get into Georgia's citizen's arrest law, which has kind of been brought up as a defense in this case. And if you'd like, I'll just go into what citizen's arrest sort of means and what it takes in order to make a proper citizen's arrest.
Yeah, please.
Yes.
So, in Georgia, a citizen has actually equal power to make an arrest of a felon on the run that a police officer does. No difference in power, technically. So, in which Georgia treats a lot of law like that, in that police officers and citizens generally have the same amount of power. So, what that means is that if you or someone witnesses someone commit a felony, that they have the ability to effect an arrest. And the whole point of an arrest means just to keep them in place, to either be brought to the magistrate for a warrant, or to keep them in place until a police officer comes who will then arrest that individual and present a warrant to the magistrate judge. So if the important factor there is that you actually have to witness the crime. And part of that means that if a group of people are involved, like we have in the Ahmaud Arbery situation, there's a neighbor who witnesses Ahmaud leave the house. Now, if that individual had witnessed a felony, then that individual would have the right to then pursue Ahmaud with reasonable force and effect an arrest. Now, something else that's important too is if it's a misdemeanor, the law does have some different effect there, is that a private person can make an arrest for a misdemeanor offense only if the offense occurs in that person's presence, and that the arrest has to occur immediately after the crime is effected, more or less. So that means if you witness someone commit a misdemeanor and then you see him the next day, you can't arrest him. That's not really something we're going to deal with in this case, because the alleged possible crime occurred immediately in front of that neighbor, but that is not the neighbor who made the arrest. Now, one of the things we got to talk about is it a felony or a crime at all what Ahmaud did? And that's entering into a kind of a partially constructed home. And that's going to be somewhat up for debate. I'm
sorry, I just want to interrupt. I just want to ask one question. So there's been comments that like a partially constructed home, it's not like a builder home, it's somebody's home who's being renovated. Does that make a difference? I mean, it's still someone else's property.
It can. It can. I think a lot of it comes down to what we call the mens rea, or the state of mind of that individual. It is generally considered acceptable, I think, in the U.S. is that, for example, when I was home shopping into some partially constructed neighborhoods, I walked into some homes that had the outside completely finished, but the inside, was still in the process of being built. And it was just a way to look at some of the houses that were going to be built in the area that had maybe yet to be purchased. What was in Ahmaud's state of mind at the time? I've seen the video, and the house looked like a gut job sort of thing going on inside there. What his state of mind was in regards to the state of that house, and if someone owned it, it would be important to know, but of course we're never going to know that. Because it is someone's house being renovated, someone could make the argument that that is effectively breaking and entering, if you want to establish that he entered that home with the intent to commit a felony. Again, we don't know if Mr. Ahmaud intended to commit a felony, and I believe even the homeowner or the construction company that was doing the renovation, their statement is they don't believe that that there was any indication he was there to steal something. Of course, that's their presumption. So someone's going to present that to a jury and say, okay, if I'm the defense attorney, I'm going to go look at the way he enters the home. It looks like he kind of does a left-right look and then enters the home, and then he enters the home a second way. I don't know what part he entered, but it looks like he tried to enter the home in a second direction. And it isn't if he committed a felony, but it's did he intend to commit a felony within? Was he looking to steal something? Now, some people will go, well, it's trespassing either way, and trespassing can be really difficult because, generally speaking, and someone needs to be warned not to enter somewhere before we really do trespass. They call that trespass notice. And even in prosecutors use a program called Tracker, and it gives us sort of the prosecuting language on indictments and accusations. And when you charge trespassing, one of the sections on it says, after being noticed by blank, not to be on the premises. So it would be tough to argue that he's trespassing unless that there's some sort of sign or he's been told not to be in there. Of course, as a defense attorney, you could certainly argue it. But what's important to even talk about is even if he breaks and enters. Let's assume he breaks and enters into that home, or he trespasses into that home. So what happens there is that the person who could have effected the arrest is the neighbor across the street who comes out and says something to him. We don't know what he says. For all we know, he might have come out and said, "Hey, what are you doing in there?" He might have come out and said, "Hey, that's, that house is not a construction site. That's a renovation. That's someone's home. Get out." Now, the issue there again is he's not the one who makes the arrest. So Ahmaud then runs, and at some point, my understanding by the McMichaels statement is he runs past the McMichaels driveway, and the McMichaels see the speed at which he's running, and they believe he matches the description of an individual who may have previously committed a theft in the area. And who that previous person might be is now who we know entered the renovation site at some time before Ahmaud, who had a lighter skin tone and had tattoos, but in fact was not Ahmaud. And they give chase. So by giving the chase there, and Dave probably knows this, being a gun guy, we sort of get knowledgeable on this fact, is that when you use self-defense is a defense of your life, or mortal injury of someone else, an innocent bystander, or innocent bystander's life. If you chase someone down over a property crime, you really forego the defense of self-defense. You're going to have to rely on things like citizen's arrest. And as I stated earlier, I think it's going to be a weak chance of arguing citizen's arrest in this case, because the McMichaels have never made a statement that they witnessed Ahmaud commit a crime. And in Georgia, a suspected crime is not enough. So, and that complicates things further. If you see a guy walk out of a construction site, you've got to be sure that he's not someone who's there working with the construction site. He's not a guest of the homeowner. The question there is that a suspected theft? Now, if he runs out and he's got a TV in his hand, okay, well, things are a little different now. It's not so much a suspected crime. You can pretty much say, okay, there's property now leaving this place. So the McMichaels are going to have to rely on citizen's arrest, in my opinion, because they approached Ahmaud armed. And if you go running in a neighborhood and people approach you with firearms, they're going to be the aggressors. That you can't argue that unless you previously attacked somebody. I just don't see how an intellectually honest person there says that person does not instigate the altercation. The question is that a justifiable action that they made? So, as we kind of move down the line of facts here, they go and take off after him. And by their own statements, it's because of a property crime. So we're pretty much having to move solely into the law of citizen's arrest. Because when they approach him, then at that point, Ahmaud either tries to disarm him or get the gun pointed away from him, and that's when the shots fire. And so their argument... Well, go ahead, Dave.
And here's the thing about where Ahmaud was. At the point that you have somebody approach you with a long gun, you have three options. One is do nothing and take your chances on whether he's going to kill you. One is to run away and take your chances of being popped in the back. Or you close the distance and you go to fight. And the tactical right decision for most people is close the distance. So it's
like they say, run from a knife, run towards a gun.
Right. Now, do I think, based on Ahmaud's background, that he was shopping for a house? No. I do enough construction work to know that stuff disappears. We were working on a house in Kirkwood where the electrician's shop vac was stolen, and Cracky tried to sell it back to him at the corner shop.
Yeah.
And that's why you don't leave stuff on job sites.
Well, and it's important for us to talk about things we know about Ahmaud. Ahmaud was on first offender probation. From my understanding, it was a weapons charge. So he's not a convicted felon, but he has had some run-ins with the law. He had some misdemeanor thefts in his past. Now, that's important to know only really for us to say what we thought Ahmaud might have been doing in that house. But it's not important when it comes to the claim of the McMichaels, because the McMichaels didn't know his criminal history when they went after him.
That's actually debatable, because the elder McMichael did have there was some evidence that he's had interaction with this guy before, when he was working the prosecutor's office or when he was in law enforcement. Now, whether or not he recognized him is plenty to debate. But the fact that he had interaction with this guy before.
Yeah, and so I don't know if he recognized him or not. I haven't heard any statements that he knew who Ahmaud was when he began to give chase. So, yeah, it's honestly probably something we're later going to figure out, or at least get statements on. So, yeah, I'm sure that's something that's going to be questionable. So, even if he knows, though, it still brings into some question of when he's pursuing him. You know, we're still going to pretty squarely sit on citizen's arrest, because there's not a current threat to someone's life, and he didn't witness something violent that had just happened, or wasn't under the impression that someone was about to be violently injured. So his approach of Ahmaud, I think, still is going to have to sit on a citizen's arrest defense, which is an affirmative defense. That means you're saying, look, I did what you accused me of, but what I did was justifiable. And that's the same on self-defense. I'm admitting I shot at or shot this person, but what I did was justifiable. So one of the things that we need to consider is that a private citizen, when they make an arrest, can only use reasonable force. Just like police, just because you're getting arrested does not mean it's necessarily a death sentence. So that also means reasonable restraint of an individual. You know, you can't. There's case law where an individual arrests someone and ties them to a tree by their ankles. You can't do that. So if you ever find yourself making a citizen's arrest, do not tie someone up to something. You know, what you should do
that sounds like way more like kink than the law.
Yeah, you would be so amazed what we see in case law. So you've got to use reasonable force. That means if you're tying someone up, it has to be in a method that's not intended to punish them. That is only a method intended to assist in bringing that person to the magistrate, meaning either to a police officer or down to the courthouse. So we've got some case law here, and more or less in a situation, an individual had a baseball bat, and they struck that person with the baseball bat before enacting the citizen's arrest.
Well, here's where things get murky, is if a police officer had tried to stop to speak to Ahmaud and had a weapon drawn, and then he closed the distance and tried to wrestle the firearm away from a police officer, that shooting would absolutely be justified.
Yes, but you have to consider how the police officer would make the stop and if it would be a false arrest. So a police officer can talk to anyone. I can talk to anyone. The McMichaels can talk to anybody. So if someone's running down my neighborhood right now, if I want to, I can get in my truck, I can pull up next to them and say, hey, what are you doing? They don't have to answer me. They don't have to stop for me. But I can certainly pull out and ask the question. As long as I don't endanger their life, commit a traffic offense while I'm in the car, or make a threat against them, what I'm doing is completely legal. It might be obnoxious, but legal. And there are plenty of things that I think qualify under the stupid but legal title that people do all the time. So an officer could pull up and say, hey, what's going on? If the 911 call had been made and the officer is made aware that an individual had possibly just been trespassing or breaking and entering, then if he had a description of that individual, he probably could have gone ahead and initiated a temporary detention of Ahmaud. And I don't know if a 911 call got made after he entered the house or not. I know that there might have been some previous 911 calls, but and you guys might be able to help me clarify that. Is there a report that a 911 call was made?
So the most recent thing that I've seen, there's claims that there was a 911 call on the day of, but the only 911 calls that have been released are the ones from the few days prior.
Okay. So, yeah, if a police officer had been told of a possible trespassing and a description of that individual, then he would have probable cause to stop individuals in that area who met that description. The issue with lay citizens is that we don't have a dispatch who calls us and says that, but we also, as lay citizens, can only stop and arrest someone that we have witnessed commit a crime. And I think ultimately that is the leg that will fall out from under the McMichaels defense, is that they're going to have to argue that by approaching this individual with guns, which on its face can be aggravated assault if they believe it was intended to cause fear of imminent harm to Mr. Arbery, then they're going to have to fall back and say, well, it was a legal citizen's arrest. And the only way to do that is going to be to say that they saw the crime, not a suspected crime, but they saw the crime, and that, or it's not an and, but or the individuals, or Ahmaud, if he admitted to the crime while he's fleeing, actually qualifies. If an admission to the felony is enough for a citizen's arrest. But I think it's highly doubtful that Ahmaud begins running and saying, yeah, I broke into the house. I don't think that's going to be a plausible outcome there.
Even breaking into the house or even scoping out to see if there's anything to steal is not a felony.
Well, if you argue he entered the house to steal, then he did enter the house with the intent to commit a felony, and you could argue that would have been a burglary. Because remember, burglary, you don't actually have to succeed. Burglary means entering a dwelling with the intent to commit a felony within. And I've literally seen people charge burglary with the idea is that the felony, the theft, is the theft of their air conditioning. So
yes, and God bless them.
So, yeah, essentially that's what they do when folks break into houses with the intent to stay the night there. So the alleged felony is the theft of utilities. And so I've seen that done before. So I think if you had the neighbor who watched Ahmaud enter the house, you would have an arguably better argument for citizen's arrest. I still think there would be a debate, and it would be a question for the jury if what that neighbor witnessed was a suspected crime or an actual crime. Because again, it's got to be an actual crime, not simply a suspected crime. And the reason we do that is so that people aren't going and trying to arrest everyone because they think something might be a crime.
Well, multiple things can be true. I mean, Arbery could be not the best guy in the world, and these two idiots could be murderers. And I think
right. I think, in fact, I think if I have to guess. And this is where I'll hazard maybe people being upset with me, but if I had to guess, I don't think Ahmaud went into the house just to, check out this house under construction. I think the way he enters the house with the lookout and then he sort of jogs inside real quick is intended probably to make sure that people, that what he's doing is safe, that he won't get he wouldn't get yelled at by a neighbor or possibly have the police called on him. Because I think either he knew it was suspicious looking or knew what he was doing itself was suspicious. If I was a prosecutor charging Ahmaud with breaking and entering, I would certainly argue to the jury, look at the way he enters into the house. Look at how he looks left and right, then jogs inside really fast. And then when he comes back out, he makes sure to quickly run around to the side of the house. I'd say that's because he's hiding what he's doing. But tying that into the McMichaels case is going to be difficult because they didn't witness it. And, there's a question if that's even going to be admissible at the trial.
That is an interesting question, is whether or not the jury will ever hear about Ahmaud's past. And I don't think we can judge crimes based on the validity of the victim. A millionaire's life isn't worth more than a homeless guy.
Yeah, and I think a lot of people, when it comes to, and I know this case is not a case of police use of force, but because of who Mr. McMichael was and how this case was treated as a citizen's arrest by the district attorney's office, I think it certainly begs the question on that. Is this related to the way we treat police officers when they've been accused of improper use of deadly force? And when a police officers in many cases have used deadly force, the individual is guilty. The question is not, is he guilty of what he did? It's, was the police officer's response legitimate and proportionate? Mm-hmm. Even if they have the knowledge of Ahmaud being in the house, we still have to ask: is getting in your car and confronting him with the gun, creating the altercation, is that reasonable force? Is that a reasonable thing that we want to have done? And that's going to be a question for the jury. I can't even tell you today, I think, if someone who chases someone down for a suspected nonviolent breaking and entering, if by blocking that person's path and getting into a physical altercation while you're holding a gun, is that going to be considered reasonable force? I think certainly because burglary is a felony. I think a lot of officers would tell you anytime they make an arrest on a felony, there's a heightened sense of what they need to do for self-defense, because they can assume on felonies, they assume that there's going to be a possible violent reaction from the offender. But that's kind of a societal question, and that's a question for juries to determine what that reasonable force is.
Well, I feel like, and we haven't really touched on this, but there's been a lot of conversation about the conflicts between the first district attorney's office, the second district attorney's office, not necessarily Tom Durden, who was appointed when all this kind of came to light, but and it's all been from the integrity of the process in defense of Arbery. But if you're a criminal defense attorney and now you're charged with representing the McMichaels, of course, none of that is going to come up in court. But how do you, is it now in a position where it is on neutral playing ground, or does the defense have concerns at this point as well?
So, bringing in a special prosecutor happens more often than people realize. I worked in Forsyth County Solicitor's Office, and, if you were a good friend of the prosecutor, he would call in to the Hall County Solicitor's Office and say, "Hey, could you guys send someone down here to handle this case? If this guy
That's
doesn't,
awesome.
if this guy doesn't want to plead guilty, then, it's not just am I biased, it's is there the possibility that I will appear biased?" Mm-hmm. And we talk about that in law all the time. It's not even if you are biased, it's would you appear biased? I don't think that when that Hall County solicitor came over that it created an unfair situation. There are times people feel things are unfair because there's a current outcry maybe against a crime. And I've certainly seen that in my practice. I've had individuals who were accused of sexual-related crimes against females. And in the kind of Me Too age, they felt that they weren't going to get a fair shake by anybody because it's just there's such an outcry for it that people are kind of really, really wanting to make sure that these individuals are found guilty. And judges are elected individuals. So if a judge looks like he's sort of aiding one side or the other, people might treat that as part of his policy perspective, rather than just simply how the law maybe ought to be. And so yeah, if you are the McMichaels, you probably feel like there's not a way to get a fair trial because the jury of public opinion has already found you guilty. And what prosecutor wants to get appointed on that who wants to come in there and exonerate these folks? That's a great way to find yourself facing a competitor in your next election who says, gosh, if it was me, I'd have certainly made them go to trial. I certainly would have indicted them. And that's tough. And that's tough, period. And we see that anytime a murder case gets national attention. If you exonerate the person who's maybe been accused of that murder, you can really end up hurting your own office. And there's a lot of questions people have about certain judicial figures being elected because of that. But that's a bigger question of how you want your judicial system to be created and run.
Well, yeah, that certainly is a concern. But Chris, we are up against time.
Yeah.
On this,
and I know I'll talk all day.
Well, lawyers, but we certainly appreciate you coming on, and thank you for your insight. And I look forward to having you on again. You're obviously very knowledgeable, and we cover a lot of legal cases.
Yeah, and I'll just say before I sign off here, if you are involved in a self-defense situation, you should make sure that it's in defense of someone's life or your own life. I would not recommend anyone to initiate a citizen's arrest, and if you find yourself where you might feel forced to initiate a citizen's arrest, you need to have a call to 911 before you do it so that it doesn't look like you were trying to do the cop's job and then call them in later. I would certainly think you should call the police before you ever try to initiate a citizen's arrest, and again, I don't recommend anyone doing it. It's a very legally dangerous thing to do.
And where can people find out more about Bulldog Bike Law?
Sure, you can go to www.bulldogbikelaww.com. We've got our website there. We also have a website at bulldogfirm.com, and you can give us a call at 770-408-7000. If you've been in an accident in a car, motorcycle, give us a call. We'd love to help you out. And we are the kind of folks who are going to take your case all the way to the end. That's why we call ourselves the Bulldog Firm. Everyone wants a bulldog for an attorney, and that's what we do. We're not the guys who are just going to settle you up and leave you out to dry. So give us a call.
Brother, thank you very much for coming on.
All right, thank you.
We are very thankful to the guests that appeared on both Part 1 and Part 2 of this deep dive into the Ahmaud Arbery case and the case of the McMichaels. Jessica, do you have any closing thoughts?
I just, everyone said it throughout the show, or both shows, but a lot more information is going to come out. There's so much we don't know from authorities. We don't know the McMichaels side, and as frustrating as all of it is, and as easy as it is to pick a side, I would just remind people that everyone is entitled to a vigorous defense, and we have to let the process work. We have to let it work the way it's supposed to, and we shouldn't stand in the way of that. So just keep that in mind in all your outrage.
Yeah, and to piggyback on that, I'll just say that it's we don't have all the information. We have a couple videos. Obviously, there's probably a file 4 inches thick sitting on a prosecutor's desk somewhere of what will be presented to the jury, and we will be interested to see how it plays out and in trial, if they actually go to trial, unless the McMichaels plead out. But what we're looking at going forward and what it means for self-defense and stand your ground in this state. So for Jessica Szilagyi, for Eric Cumby, For Chris Howard, our guest on this second segment, I'm Dave Roberts. Have a great week.